So today we are diving into a whole stack of articles about the Sanchar Saathi application controversy.
And this really isn't just a tech story, is it?
No, not at all. It's a huge legal and, I think, architectural battle. And it's all unfolding in one of the world's biggest smartphone markets.
Absolutely.
Our mission today is to really unpack this core tension, the one at the heart of digital governance. How does a modern state fight something like cyber fraud, which is a real problem, without completely sacrificing our digital autonomy?
And you have so many players involved. You've got India's Department of Telecommunications, the DOT.
Right. And then you have this huge pushback from privacy advocates, from cybersecurity experts, and even, surprisingly, from giants like Apple.
Well, and we have to say right up front how fast this all escalated. The initial mandate was binding. I mean, it required pre-installation on all new devices.
Wow, okay.
But the backlash, both legal and from a privacy perspective, was so intense that the government, well, they walked it back pretty quickly. They removed that mandatory pre-installation part.
And that move alone just shows how contentious this whole area is.
Exactly. That initial retraction is really key context for everything else we're going to talk about.
Okay, so let's unpack the government side of it first.
Yeah.
From their perspective, the Sanchar Saathi platform is all about consumer protection.
That's the stated goal, yes.
It's meant to curb things like IMEI tampering, phone theft, and maybe most importantly, shut down all those fraudulent mobile connections that are, the first step in so many scams.
And the functions themselves, on paper, are pretty compelling. They address a very real problem for millions of people. The main thing it does is help you block a lost or stolen phone.
Right, by blacklisting the IMEI number.
Precisely. It blacklists that unique identifier across every telecom network through something called the CEI database. That's the Central Equipment Identity Register. It basically turns a stolen phone into a brick.
It also helps you manage your identity right, like checking if someone's using your ID for other SIM cards.
Exactly. It lets you spot and disconnect any unauthorized SIMs that might be fraudulently linked to your name. Scammers use stolen IDs to activate hundreds of SIMs, and this is designed to sever that link.
And based on the numbers we're seeing in these articles, it seems to be working.
The numbers are pretty staggering.
Over 10 million downloads, 4.2 million stolen devices blocked, and this is the big one, over 30 million fake or fraudulent mobile connections shut down.
I mean, those figures are huge, and they definitely show the platform is effective at solving that specific kind of low-level telecom fraud problem.
But that's where the experts start to push back.
This is where the nuance comes in. Cybersecurity experts argue that an app embedded this deep in your phone is only really addressing the very first stage of fraud. The foundation.
Hold on, though. If they've shut down 30 million fraudulent connections, doesn't that suggest this deeply integrated app is necessary? I mean, doesn't the sheer scale of the problem justify this kind of intervention?
That's the crucial question. The counterargument is that Sanchar Saathi, while it's good at stopping phone theft and basic SIM fraud, is aimed at the wrong target for today's biggest cybercrimes.
You mean things like phishing and those fake loan apps?
Exactly. We're talking about really sophisticated social engineering, SIM swap fraud, where a criminal literally steals your phone number to empty your bank accounts, or remote access scams where they trick you into installing hostile software.
And huge cross-border call centers.
Right. And the experts say that stopping that requires action at the financial network level. Better security at the banks, stronger two-factor authentication, consumer education, not a phone site app that's mostly just tracking IMIs and SIMs.
So it's like trying to stop a bank heist by checking the license plate on the getaway car.
That's a perfect analogy. It addresses a piece of the crime, but not the part where the real money is lost.
And that pivot takes us right into the core constitutional fight. If the goal is legitimate, why did the plan to mandate this app set off so many legal alarm bells?
The alarm bells were all about the legal instability. Critics immediately called it the mandatory voluntary toggle.
What's that mean?
Well, initially, the DOT's directive was crystal clear. Manufacturers had to preload the app, it had to be visible, functional, and you couldn't disable it on first use.
But then they changed their tune.
Completely. When the criticism got loud, the union minister came out and said, no, it's optional, you can delete it.
It sounds like they were trying to have it both ways.
That's the exact legal critique. Privacy advocates point to things like the Aadhaar rollout and say, this is a familiar strategy. You build facts on the ground. You force manufacturers to embed your app so the state is already on the device from day one.
So even if the user can delete it later, the coercion has already happened.
That's the argument. And a minister just saying, trust us, it's optional, isn't a real legal safeguard.
Why not?
Because a statement of intent isn't a law. It can be changed tomorrow. For any state action that interferes with a fundamental right like privacy, it has to pass the Puttaswamy test.
Okay, let's break that down. That's the huge 2017 Supreme Court ruling that made privacy a fundamental right.
Correct. And it lays out three conditions. First, there has to be a clear legal basis, not just a clarification. Second, a legitimate public interest, which fighting fraud definitely is.
And the third.
The third is proportionality. And this is where Sanchar Saathi really struggles.
In simple terms, proportionality means what?
It means the solution has to be the least invasive option possible to get the job done. If there are other, less intrusive ways to stop fraud, and critics say there are, then forcing a pre-installation like this fails the test.
So, trust me, from a politician, just doesn't cut it legally.
Not even close. In the eyes of the law, that's a failure of proportionality. And this kind of invasive architecture is the perfect breeding ground for something called function creep.
Right, function creep. The idea that a system built for one thing can slowly have its purpose expanded over time without anyone really noticing.
Exactly. It's the biggest systemic risk. You have this embedded system designed today to do something simple like check an IMEI number.
But because it's already there, deep in the phone system.
It becomes incredibly easy and cheap down the road for its capabilities to be expanded, maybe to monitor something else entirely, all without new public debate or a new law being passed.
There was that great quote from a privacy lawyer that really captures this. Something like, government has no business being in our devices that are more intimate to us than our loved ones.
That really sums it up. It speaks to the incredible level of trust we place in these things we carry in our pockets.
Okay, so to really understand that risk, we need to get into the weeds a bit, the technical side of the intrusion. Security analysts looked at the specific permissions the app asks for on Android phones. What did they find?
Well, this is what really worried the tech community. The app asks for a list of what are called dangerous permissions. It needs to make and manage phone calls, send SMS messages for registration, sure.
But the critical one was access to call and SMS logs.
That's the one. It demands permission to read your call and SMS logs.
And why is that so dangerous? Even if the government says they won't read the actual content of our messages.
Because it's not about the content, it's about the metadata.
Explain that.
Think of your communications like a letter in an envelope. The content is what's inside the letter. Metadata is everything on the outside of the envelope. Who you sent it to, who sent it to you, when, how often.
So just from that data, you can map out someone's entire social network.
Their entire life, their business contacts, their patterns of communication. Metadata is incredibly powerful for profiling and surveillance at a population scale. Giving an app access to those logs, even just for reporting fraud, opens up this incredibly sensitive data.
And this gets worse because it was meant to be a deep system application, not just a normal app.
Exactly. So when the minister says it's deletable, that's technically a bit misleading.
How so?
When an app is installed by the manufacturer in a system partition, it gets special privileges. For most people, hitting delete might just remove the icon from their home screen. The underlying package with all its hooks into the phone's core functions could still be there.
And you'd have to root your device to truly get rid of it.
Which almost no one does because it's complex and voids your warranty. So for most people, the deletion is symbolic, not functional.
This whole issue was really thrown into sharp relief by Apple's response, wasn't it?
It was a clarifying moment. Apple basically told the government they would not comply with the mandate for iPhones.
And their reason.
Core design principles. The iOS operating system simply does not allow third-party apps to access user call logs or manage telephony functions like that. They argued the mandate fundamentally violates the iPhone's privacy architecture.
And that refusal creates a massive societal problem, what our sources are calling a two-tier privacy regime.
It's a stark division. Most citizens in India use more affordable Android devices where the operating system does allow this kind of deep state access. But iPhone users, who are generally a smaller, wealthier group, are protected by the technology itself.
So your fundamental right to privacy ends up depending on how much you can afford to spend on a phone.
Instead of being a universal constitutional guarantee,
Yes.
and all of this is happening where there's a big governance gap.
Meaning no independent oversight.
Right. The policy says the data can be shared with law enforcement when required by law. Without a truly independent data protection agency to audit that, Critics worry it just becomes an open channel for surveillance, with no one to hold them accountable.
So this whole debate, it's not happening in a vacuum. It fits into this much larger global conversation about digital identity systems.
It absolutely does. You see the same tensions playing out with Aadhaar, with the EU's IDS framework, and the DATI's directive here gets its power from the new Telecommunications Act of 2023.
Okay, what does that new act say that's relevant here?
Well, it grants the state some very broad powers. Section 22, for instance, allows the government to collect and analyze traffic data, which is basically metadata for cybersecurity purposes. It formalizes the state's ability to do this kind of analysis at scale.
And what about identity?
Section 37 mandates that telcos have to identify users with verifiable biometric-based identification for certain services. The whole legal environment is built to prioritize state access and verification.
So the new law makes this kind of thing legally possible, but that still brings us back to that question of proportionality.
Precisely. If the goal is a human-centered digital identity one that actually balances security with privacy and accessibility, then proportionality is everything. The solution can't be excessive.
And the sources are clear that the main fraud prevention tools, the IEI check and device blocking, already exist in a much less invasive form.
Yes. The government already runs web portals and SMS services where you can report a stolen phone or check an IMEI. They achieve the same stated goals without needing any deep permissions, without touching your call logs, and without being embedded in your phone's system.
That feels like the smoking gun for the legal challenge.
It is. The least intrusive alternatives are already built and working.
So the obvious question is, if the simple method works, why mandate the complicated, privacy-invasive one?
Because the more complex one enables future capabilities. That's the fear. Civil society groups have proposed clear, proportionate alternatives.
Like,
Make the app fully opt-in. Drastically limit its permissions to only what's absolutely necessary. Publish the source code so it can be audited independently. And crucially, don't let it be installed in those privileged system partitions. The goal should be maximum fraud prevention with minimum privilege.
so this deep dive really just lays bare the friction between, a government trying to solve a real problem and the digital rights of its citizens.
It's a classic case study.
You have the clear success in fighting basic fraud. Millions of stolen phones blocked. But it's set against these profound legal and technical risks from the mandated architecture of the solution.
That's the key word, architecture.
So the main takeaway for you, listening to this, is that the issue is less about the government's current intent, which is fighting crime, and much more about the mandated architecture. An architecture that, as critics warn, enables population-level metadata capture and creates a clear path for function creep.
And that leaves us with a final thought. In a world where our devices are, as that lawyer said, more intimate to us than our loved ones, and digital identity is the key to almost every essential service, we have to scrutinize that architecture. When a state mandates a system-level tool, we have to ask, are we building these systems with inherent technical limits and guardrails to protect democracy? Or are we just relying on political promises that could change with the next government or the next crisis? That's the line we have to watch.